Thanks, Sasha, and lovely to meet you all and connect with you. Obviously, thanks for coming along today. And just on that, with the questions towards the end, we will have Q&A at the end. If they are too specific, I will need to be a little bit careful with what I can say. More than happy to jump on another call with you and get into the details, though, around your particular issue. But just be mindful that obviously we are still in sort of like a public forum, and I have to keep a lot of my advice, relatively general in that sense. So, but look, with that said, I'll definitely try to get to the nub of the issue as soon as I can. Rightio, kicking things off. Built to last, a legal playbook for startup founders. As Sasha sort of said, a little bit about Lawpath. We do have a pretty jam-packed session, so I'll keep this relatively short. But built to last, that is quite a deliberate choice of words. So this isn't a session about how to lawyer up. It's a session about how to build a company that survives the things that break most early stage businesses. So before we dive in, as I sort of said, we'll have questions at the end. So drop your questions in the chat as they come up. And the other thing I'd also like to just bring up is that every attendee here will get a free 30-minute consultation with one of our lawyers at Lawpath. So obviously, if you do need to go to that next stage with your questions, we can definitely book you in for one of those consults and get cracking. So about Lawpath, we've been doing this for about a decade now. I actually did an internship with Lawpath 6 years ago before going on a corporate lawyer career, and now I'm back here. So they're obviously doing something right. It's one of the quickest, most interesting growing law firms, I think, not only in Australia, but most common law countries, I think, too. So it's a bit of a unicorn in the sense that we do things very differently. But yeah, we've helped around 650,000 Australian businesses get the legal, tax and compliance sort of help that they need. We've saved them over $500 million in professional fees along the way. So we're definitely very proud of that contribution that we've made to the market. I'll keep this very short. No one wants to hear lawyers yap on about themselves, but yes, commercial lawyer, spend most of my days helping small businesses with contracts, structures, employment, some of the unglamorous stuff like, litigation and disputes. And again, I do often say, unfortunately, sometimes we are the worst case scenario merchants. We have to force founders and our clients to think about worst case scenarios so we can protect you against those if they do ever occur. So in today's session, there's 6 parts. So we'll start with structure, getting the company right from day one, then founder agreements, which is where most of the disputes either get prevented or set up to really explode in many instances. Raising capital, the difference between a safe and an equity round and what investors actually look at. Hiring risks, especially the contractor versus employee question that catches almost everyone out in some way, shape or form. Then we look at risk prioritization, what you actually need to do in year one versus what can wait. And then we'll wrap up with real scenarios and a Q&A. So I hope this session is right for you based on that. So have a quick look at these 4 scenarios. If any one of them describes you, you're definitely in the right place. Maybe you've just incorporated or you're not 100% sure you set it up correctly. Maybe you've got a co-founder and the only thing in writing is a Slack message or a Teams message or an email saying, let's do this together. Definitely seen that happen before. Maybe you're getting close to a raise and the legal side suddenly feels important in a way it didn't 6 months ago. Or maybe you've been at it for a year or two and you've quietly realized you've been winging all of the legals on the side. So wherever you sit on that list, this session is definitely built for you. Now, before we dig into the practical stuff, I want to set up sort of why some of this stuff matters as well. I want you to take this in because it's really the thesis of the whole session. Most startup legal problems are completely preventable. I do want you to really actually have a think and reflect on that. And the ones that aren't preventable, the genuinely complex, novel situations are usually the ones nobody bothered to document along the way. The complexity comes often from the absence of documentation, not the situation itself. So why this matters? The hard truth about startup legal problems. 65% of startups fail because of co-founder disputes. That's a number from Noam Wasserman's Founders Dilemmas, a Harvard study, cited and recited for over a decade because nobody's been able to argue it down. There hasn't even, some of these Harvard studies go back to even 2012. So 65%, that's more the market fit. So more than running out of money, more than competition, the people you started the business with are statistically the most likely thing to kill it. So I just want you to sort of really reflect on that. Sit with that for a second, because the most common reason businesses die is something that's almost entirely about communication and documentation being two or three people. When you really have a think about that, it's not complex, it's not unsolvable. It just goes unaddressed because the conversation often feels uncomfortable, and that's completely fine. Like, some of these things can be confronting to deal with. And here's the part that should be more encouraging. The founders who get this right aren't the ones who spend most on lawyers. They're the ones who know which 5 things matter in year 1 and actually do them. 3 scenarios. I'm going to walk you through them quickly because I bet at least one of them will sound familiar. Scenario 1, the co-founder split. 2 people who built something together fall out. Maybe one wants to go full time, the other still sits on the fence. Maybe priorities shift. Maybe it's just a personality clash. Nothing was documented. One of them walks away with half the company, keeps every share they were issued, and contributes nothing to what comes next. The remaining founder is stuck, really, building the business while their ex-co-founder owns almost half of it. The second scenario, the first hire dispute. You hired someone as a contractor because it felt easier. They've been working full-time on your laptop, taking direction from you for 9 months. The relationship breaks down. They file a Fair Work claiming that they've been an employee the whole time. You can show them that they're a contractor. It says contractor. The document might even say that. Fair Work doesn't care about the contract. They care about the actual relationship, and the actual relationship looks like employment. And scenario 3, the one most founders don't sort of see coming. You're raising, the investors are keen, they ask for a fully diluted cap table, and that's when the wheels come off. There are 3 people who are verbally promised equity. There's a safe you signed 2 years ago that nobody's tracking. There's an option pool that exists in spirit but not in any document, and the investor goes quiet. Definitely seen this third scenario happen a few times. Let me be really clear about what we're not saying. Built to last doesn't mean lawyering up on day 1. It doesn't mean spending 20 grand on legal before you've made $1. And it definitely doesn't mean treating every conversation like a potential lawsuit. That's exhausting, and it makes you a worse founder and business operator, almost certainly. What it does mean is knowing which 5 things actually matter in year 1, doing those well, not ignoring them until they become expensive. And building a foundation that holds up when it actually gets tested by an investor, a co-founder leaving, or a team dispute is really important. The whole point of today is to give you that list of 5 things and a sense of when each one really matters. Quick note from a founder, published Invested's Startup Horror Stories last year. When we set businesses up, I was very naive, and we didn't have a good corporate governance in place. My co-founder stopped contributing but still wanted equal say. Without a proper agreement, there was nothing I could do. The 3 things to notice in that quote: there was no mechanism to adjust equity when contribution changed. There was no vesting schedule. So the disengaged co-founder kept their full stake. And there was no dispute resolution clause. So litigation really was the only path forward, or is the only path forward there. 3 documents away from a completely different outcome. Every single one of those scenarios is preventable, every one. And the founders who build companies that go the distance, the ones we see succeed at Lawpath, the ones who get acquired, the ones who hit Series A, they're not the ones who spend the most on lawyers. They're the ones who get the fundamentals right early, documented what mattered, and knew what to worry about versus what could wait. So coming into our first part, structure. The first decision, what entity you're going to operate under. You've got 3 real sort of options here. And for a startup, the answer is almost always the same: a proprietary limited company. It's the right structure for nearly every startup I see. It limits your personal liability, which means if the business gets sued, your house isn't on the line. It's required by virtually every institutional investor, and even some of the more, just institutionals a high bar, even other angel investors and other groups out there. And on Lawpath, you can set one of these up in about 15 minutes. You can get your ACN, register for an ABN, and you're trading. The alternatives, I guess, to that, a trust can also be useful for tax distribution, but it's not an investable. It's not investable in the way that investors expect. So I wouldn't always run straight to a trust. The cap table mechanics can often get quite messy. A sole trader is fine if you're a freelance designer or a consultant, but you've got ultimate personal liability there, which is no place to be when you're building something meant to scale. And a partnership has very similar liability problems with no separate legal entity. So if you're building something that's going to grow, hire people, take investment, it's a proprietary limit almost all in every case. The conversation usually doesn't need to be longer than that. Here's the line that gets the most pushback, I would say, and one that I think I most need you all to hear in the founder category. The 50-50 quite often feels fair on day one. It creates deadlock problems, though, on day 365. And I do want you to sort of dwell on that. It does sound like it's the right thing to do at the time, but it does and can give issues further down the line. So I'm not saying never to do it. I'm not saying go in with your eyes open. A slight imbalance, 55, 45, 60, 40, gives someone a deciding vote when you genuinely can't agree. And there will be moments when you genuinely can't agree. The example I use is Atlassian. So Mike Cannon-Brooks and Scott Farquhar, an Australian success story, beg my pardon. They are 50-50, and it does work for them because they've been aligned for over 20 years and they've got proper governance underneath. 50-50 can work, but it requires alignment that you can't necessarily count on at the start, and proper structures to break ties when alignment fails. Now, that company nowadays doesn't operate in the same sort of way. Whilst they started there, they certainly haven't ended up there, with Mike Cannon-Brooks having far more operational control and say on how the business is operated. Second point, equity should reflect long-term contribution, not who really had the idea first. The person who quits their job to build it full-time deserves more than the person who came up with the concept but won't work in the business. That's an uncomfortable conversation that can often happen between founders, but you need to have it. The third point, and it's almost non-negotiable, whatever the split, attach it to a vesting schedule. And we'll come back to that in a few slides, but it's definitely very, very important to have. If you do nothing else from these slides, build a contribution matrix: time, capital, skills, IP, the opportunity cost, plot it out. Start to lock down how that looks. If the split doesn't match the reality of what each person's putting in, renegotiate now, not in 18 months when there's actually money on the table. Director's responsibility. So when you become a director, and as a founder, you're almost certainly a director, you're taking on legal duties, not just suggestions, duties with personal consequences. And this can often be conflated with, when you do set up a company, you're not personally liable for them, for the liabilities of that company, but there are certain duties that will apply to you personally when you step in as a director. So it's important that you understand those. Two of these matter more than others on a daily basis. First, you have to act in the company's best interests, not your own. Sounds obvious. The breach is usually subtle, using a company asset for personal projects, signing a contract with a related party without disclosing it. Directors who breach some of those kinds of duties do face personal liability. So it's really important that you understand these. Second, and this is the one that catches a lot of founders out sometimes, you cannot keep spending company money once you know or should know that the company can no longer pay its debts. That's insolvent trading. And it's one of the most common breached directors' duties, and it's one where directors get personally pursued for company debts later on by liquidators, administrators, whoever steps into the company's shoes once it goes through a winding up application. The other three on the slide are real but more procedural: disclose conflicts, keep proper records, stay up on top of tax and super. Worth knowing that the directors can be personally liable for unpaid pay-as-you-go and super, which also surprises a lot of founders too. ASIC obligations. So first 5 things ASIC expects from you, and I've flagged the 3 that catch people out. Number 1, register the company and get your ACN before you trade, invoice, or sign a contract. I see founders invoicing from a personal ABN for the first 6 months because it felt easier. Then they want to assign that revenue to the company, and then there's a tax problem and a structure problem and then an investor problem all really at once. So it's definitely something to do straight off the bat. Number 2, update ASIC within 28 days of any change, whether that's directors, shareholders, registered address. If you don't, you will see late fees apply. That also applies to shareholders, if I didn't already mention that. So you have 28 days to notify ASIC through a form 484, and they're free. If you log in and get your corporate key, you can log into the ASIC portals and lodge these for next to nothing. Number 5, I'll jump straight to there. This is a big one. Every share issuance needs a board resolution and a share certificate. An email saying you own 5% is not a legal share issuance. Investors will discover that in due diligence, and it will become your problem pretty quickly down the line. So another key obligation. This is a quote we hear regularly at Lawpath, paraphrased to protect the guilty. We never got around to setting up the company properly. We'd be invoicing from a personal ABN, promised equity verbally to 2 people, and then an investor asked for a structure chart, and there wasn't one. Unwinding informal structures takes weeks of legal work. It's not an easy task, and it often costs thousands in fees. Sometimes more, depending on how tangled the personal and the company finances have got, but it does take a lot of unwinding to do. Verbal equity promises become disputed claims the moment there's money in the room, almost always. And there's always money in the room eventually when you get down this path. So really setting up correctly at the start, one afternoon, a few $100s, the maths is not subtle. I've definitely seen plenty. I did have a client, I think it was a number of years ago, where they had been trading under their own sole trade. They had a sole trader entity up front. They had a pre-incorporation agreement with someone that was somewhat informal. They then decided to go and work together. They didn't keep accurate records. When it came to incorporation time, actually just getting together and incorporating the company, they had massive disputes over each other's liabilities, expenses, on how they generated the revenue. Basically, all the steps that they were taking to get to the point of corporation, of actually setting up the company, was already in dispute. So again, it's definitely something I recommend jumping into straight away. Part 2, founder agreements. A founder agreement is not a sign that you don't trust each other. It's a sign that you're both serious. Couples who write prenups are not the couples planning to divorce. They're the couples thinking long term and about how to protect each other if the relationship goes sideways. The agreement exists for the hard times, not the good ones. So it is, again, it's a confronting thing to think about, but always worthwhile. When the relationship is working, you don't need the document. It gets put in the drawer, locked away, no one ever reads it ever again. You need at the moment a co-founder, though, wants to leave, or priorities diverge. They might have a new business idea that they're running off to do, or an acquisition offer lands and you don't agree where and whether to take it. And here's the key insight. The document doesn't have to prevent the breakup. It just means the company survives the breakup. I hope that, again, I really want you to focus on that last point. It just means the company can survive. So what does it need to cover? 6 things: roles and responsibilities, who's CEO, who controls product, who controls finance, the equity split with a documented basis, a vesting schedule and cliff, IP assignment to the company, exit mechanisms where there's good leaver versus bad leaver, and a dispute resolution clause, mediation before litigation almost every time. Vesting schedules, how they work. So vesting means you earn your equity over time rather than owning it all up front. It protects the company and it protects the other founders if someone leaves early. The standard schedule is 4 years with a 1-year cliff. Cliff means if a co-founder leaves in the first 12 months, they get nothing. None of their equity is vested. After the cliff, equity vests monthly over the remaining 3 years. So at month 13, they've earned 25% and it accumulates from there. Why does this matter so much? Without vesting, a co-founder who leaves at month 6 keeps 100% of their stake. They contributed almost nothing to a 4 or 5 year build. They keep half the company, and we see this constantly. It's painful and preventable. A textbook example, really, if I can just jump into a little story, is Eduardo Saverin, one of the original Facebook co-founders, and it's actually displayed in that movie. His shares didn't have a proper vesting schedule. When he stopped contributing, the only path the remaining founders had to dilute him was a contentious round of issuances, and it ended in litigation. They ended up settling, but it shaped the company in ways no one really wanted. A vesting schedule on day one solves that problem. 2 more pieces, acceleration clauses. Your equity can be set up to vest faster on a company exit or acquisition, and it's worth including, especially for founders who are critical to closing a deal, or if it's critical to closing a deal. And if you've already issued shares without vesting, you can apply a vesting schedule retroactively. It requires everyone to agree, no doubt, but it's done all the time. Planning for exits and disagreements. So these are the questions your founder agreement should answer. Read through them. I just want to highlight 3. How is equity brought back when someone leaves, and at what price? Fair market value, a formula, a discount for early departure. You need to decide this when you're friends and not when you're not. Good leaver versus bad leaver. Does the reason matter? Most well-drafted agreements treat these differently. A founder who leaves because of illness or family circumstances is treated more generously than one who leaves to start a competing business or, for whatever reason, it doesn't pull their weight. I would get specific, and I often advise people to get specific about what each category means. And lastly, drag along, tag along rights. This is really talking about the acquisition scenario. Drag along means the majority can force the minority in an acquisition. So a small holdout can't block a deal that's good for everyone. And tag along means the minority can join a sale if the majority sells. So if they don't get left holding shares in a company that's no longer the same one, both really should be in your agreement. When founder relationships break down. So there's 2 paths when a founder relationship breaks down. Without an agreement, it's basically litigation. The company gets damaged. The outcome is unpredictable and can often take years and very expensive. With a good agreement, you can exit in weeks. Equity gets bought back at a known price. Roles get reassigned, and the company keeps going. As I mentioned before, 65% of startup failures involve co-founder disputes. Almost every one of them was preventable with basic documentation. That's not being dramatic. That's the data. Part 3, raising capital. This is where I really get the most questions and where the biggest unforced errors can come in. So SAFE first equity round. The 2 main instruments at the early stage are SAFE, a simple agreement for future equity, and a priced equity round. They serve different purposes. A SAFE is the investor giving you money now in exchange for equity at a later round, usually at a discount. You don't need to agree on a valuation today. It's cheap, it's faster, cheaper, simpler. For most founders raising their first 500,000 to sort of $1 million, a SAFE is usually the right instrument to move ahead with. The risk, and this catches a lot of founders out, is that multiple SAFEs at different valuation caps can compound into significant dilution at your Series A. You think you've raised 300 grand on a friendly basis. The maths at conversion shows you've actually given away 15% of the company. And, that's not ideal, not exactly what you wanted on first instance. So read the caps, model it out. A price equity round is shares sold at an agreed price now. It requires a valuation negotiation, more paperwork, and more legal fees. It's more appropriate once you've got real revenue or traction because you've got something to negotiate the valuation against. The upside down is everyone knows exactly what they own from day one. Sorry, the upside is everyone knows exactly what they own from day one. Understanding your cap table. Your cap table is a record of who owns what and what they paid for it. It starts simple, 2 founders, 50-50. It gets complicated fast once you add investors, an option pool, and safes. The key term to know, fully diluted cap table. This means all the shares that could exist if every option vested and every safe converted. When I say that, it's everything that every security or potential instrument that's been attached That's what the fully diluted cap table is. Investors will ask for this before committing to almost any investment in this space. If you can't produce it quickly and cleanly, it's usually a red flag, and it tells the investor you might have other things you're not tracking. Maintain it in real time, not just before a raise. The common mistakes I often see: safes aren't shown, informal equity promises not included, the option pool not accounted for. All of these surface in due diligence, and they all chip away at the investor's confidence in your business. And one thing founders don't always realize, what you give up in a raise isn't just equity, it's information rights, it's board seats, protective provisions where certain decisions need investor approval, anti-dilution provisions. You need to know what you're agreeing to before you sign. A lawyer reviewing a term sheet for an hour might be the cheapest hour you ever spend. So here are the early mistakes that haunt founders really at Series A. 6 mistakes, and we see all of these regularly. Shares issued without proper documentation. Just an email saying you own this much, a verbal equity promise to advisors, contractors, early employees. These become claims when the company has value. No vesting schedule before the raise. Your investor will require one, and now it's a negotiation. Safe's not properly disclosed on the cap table. The investor sees a clean version and discovers the messy one in due diligence, and trust is almost gone immediately. IP not formally assigned to the company, code and design sitting in a founder's personal name, which is a major issue, and mixed personal company finances, which makes clean due diligence basically impossible. Some of the key mistakes that we see. Now, here's a real scenario, and we often call this the most expensive handshake in startup history. Reggie Brown was one of 3 original founders of Snapchat. He came up with the core idea, disappearing messages. He named the company. He designed the original Ghost mascot. He filed the original patent alongside Evan Spiegel and Bobby Murphy. There was no founder agreement, no defined equity, no IP assignment. He was pushed out of the business with nothing, no credit, no compensation. He sued in 2013. Snapchat settled in 2014 for $157.5 million. 50 up front, and the rest paid out by 2016. The number became public in Snap's IPO filing, and in early 2017, as part of settlement, Brown was formally credited as a co-founder. Now, the root cause: a founding contribution with nothing in writing. A founder agreement and an IP assignment, 2 documents, would have resolved that on day one. For Snapchat, it was $157.5 million, and it was an expensive lesson. For Australian startups, the dollar amounts are smaller, but the dynamic is identical, and we see it every week. Part 4, hiring risks. So the contractor versus employee question is the one that catches almost everyone. The label on the contract is not what determines the answer. The actual relationship is. The ATO and Fair Work look at 4 things. They can also look at other things as well, but these are the 4 main ones that we see. Do they work exclusively or mainly for you? Do you control how and when they work? Do they use your equipment and follow your processes? And do they bear any financial risk? If the answer is yes, mostly mine, mostly yours, no, then they're an employee. The contractor you signed, calling them a contractor, doesn't change that. Here's the example I use: a developer working 40 hours a week on the laptop your company gave them, taking direction from your founders or CTO, only working for you. That's an employee. Doesn't matter what the contract says. Fair Work looks at the actual arrangement, not the document. Misclassifying isn't a paperwork problem, it's a financial liability problem. So it's not something you can just write your way out of. The real cost of misclassifying a contractor. So 1 in 5 startups using contractors in years 1 to 3 has at least 1 misclassified worker. So the odds are this is a thing in your business right now. What does it cost when it surfaces? Well, it's back payment of entitlements, annual leave, personal leave, long service leave, superannuation at 11.5% on every dollar you've paid them, plus penalties for late payment. You can see the potential for the penalties and a lot of this money to add up is quite suffocating. On a tight runway, a surprise $40,000 to $80,000 isn't just painful; it can be existential. I've seen it kill companies before. The fix is straightforward. Get the right contracts, review your actual working relationship, not what you wrote in the contract, what's actually happening day to day, and get advice before you engage someone, not after there's a dispute. Giving equity to early hires. 5 things I think you need to know if you are giving equity to early hires. I'll dwell on 3 of them. First is use an employee share option plan or an ESOP or an ESOP, not verbal promises. Not I'll give you, 1% when we raise, options granted at strike price, vesting over time, converting to shares on exercise. That's what we want, not a promise. That's the legally correct vehicle for employee equity in Australia, and that's what investors expect to see. Second, set aside an option pool before your first institutional raise, typically 10 to 15% of the company. We set it up before you raise because if you set it up after, the investor will require it to come out of the founder's stake, and that's a real number coming out of your pocket. Thirdly, and this is where founders get caught, tax matters. The ESS rules in Australia have specific tax treatment, and if you structure it correctly, employees can avoid an upfront tax bill on options that haven't been vested yet. If you structure it incorrectly, your first hire gets a tax bill on equity they can't sell. So again, I would get advice on this. It's worth doing right and doing it once. The other 2, use a proper ESOP deed with board approval for every grant and make sure your employees actually understand what they have. Options aren't shares, they eventually vest. They can expire and people should know that. Part 5, what to do first. 6 things in year 1 in sort of rough order. 1, register your proprietary limited, get your ACN and ABN before you invoice or trade, 15 minutes on Lawpath. 2, sign a founder agreement with vesting schedules before anyone writes a line of code or pitches to an investor. It's really a non-negotiable. 3, assign all IP to the company, including anything built before you incorporated. That needs to be a formal assignment, not assumed. 4, set up an ASIC compliant share register. It's required from day 1, often forgotten until an investor asks. And 5, get a proper contract for every person doing work for you, employment or contractor, depending on the actual relationship, signed before they start. And 6, talk to a lawyer before you sign any safe or convertible note. Understand what you're actually agreeing to, especially valuation caps and conversion triggers. 6 things, most can be done in a week. Then none of them are expensive. All of them save you significant pain later. So what can wait versus what really can't? Things you don't need to worry about yet, a complex shareholders agreement. You don't need that until you actually have investors. A formal board structure, same before an institutional raise. A full HR policy, usually fine until you've got 5+ employees, and international trademarks. Get the Australian one validated first before you go across the globe. Again, it's very expensive. Things that genuinely cannot wait: co-founder equity documentation, IP assignment, written contracts for anyone doing work for you, a basic understanding of your direct obligations before you start spending company money, and ASIC registration before you trade or invoice. If you've done that second list, you've done 80% of the legal work that matters in year 1. The top 4 mistakes we see at Lawpath every week. So 4 mistakes we see every single week. If any of these describe you, this week's the week to fix it. Okay, so no founder agreement. Again, we say it all the time because the conversation feels awkward with a friend. The dispute that follows is far more awkward, really, than the conversation would have been if you just did it from the start. IP not assigned to the company, so codes, designs, brand assets sitting in the founder's personal name. It's a major red flag in due diligence. It's easy to fix today, but painful to fix in year 3 or when an investor's looking. And so that's the stuff that you're building and working on before you make that decision that you're going to start up a business. Once that decision is made, make sure that assignment happens. It's very easy to do. Mixing up personal and company finances. Using a personal bank account for company expenses, we see it all the time, creates an accounting and legal problem that are really expensive to unwind. Get a separate business account, run everything through it. It's the best way to do this. It's, again, I've said it a few times. It can create a significant issue. Even when things go wrong, it can come back to you personally if you're a director mixing this sort of money together. And lastly, the informal share issuances. The email says you own 5%. That is not a legal share issuance. It needs board resolution and a share certificate. Both take 15 minutes. Rightio. Part 6, your next steps. 3 things that you guys need to do this week. 3 things, not 3 months. I'm sure we can do it this week. 1, if you've got a co-founder and no written agreement, make the time this week. Use the Lawpath co-founder agreement template as a starting point. Takes a few hours, not days. Get it done before your next investor conversation, almost certainly. 2, log into ASIC Connect right now and confirm your company details are correct. If you can't log in, you have an ASIC agent, contact them and make sure everything's up to date. Get them to send you an information layout of, all the current information and review it. Director details, registered addresses, annual review status. Again, 5 minutes. If you've missed a deadline, you'll know, and the longer you leave it, the more it costs. 3, identify everyone doing work for you without a written contract right now. List them, get contracts signed this week. Employment or contractor, whichever applies. Don't let another hour of work happen until it's documented. This can also tie back to your intellectual property stuff as well. So if people are doing work for you and you haven't got the appropriate IP assignment for the people who are working for you, you're going to have a real issue down the line when due diligence is done. Again, I said at the beginning of the call, we're giving you guys a free 30-minute legal consultation. So every attendee today gets a free 30-minute consult with a Lawpath lawyer. There's no catch. There's no pressure. I think I'm just giving you some tips of how to get the most out of it. I think the first thing is write down all your questions before the call. Be as specific as you can. Not do I need a structure or, give me just an overview of everything. I think the most value we as lawyers can give you, especially in the Lawpath model, is the more specific you can make your question or raise your issue with us, the more value we can add. 2, know your current setup. What structure you're operating under. Have you issued any shares? Is there a co-founder agreement? We can only meet you where you are. So know where you are before the call. 3, identify the one thing that sort of most feels unresolved. The 30 minutes can go fast. So I would prioritise the legal question, creating the most uncertainty for you, and lead with that. Again, lawyers I'd like to think we try to be merchants of certainty. We try to make parts of your business that are uncertain as certain as possible. And 4, bring your documents. If you've got a contract, a safe, or a term sheet you're not sure about, share it before the call so we can come prepared as well. How Lawpath can help. 4 things we do these are really the key sort of 4 things we do at Lawpath that can definitely help you guys. On-demand legal support. So you can access qualified lawyers for contract reviews, advice, negotiation help without paying senior partner hourly rates. Custom contract drafting and review when you need something specific. There's over 550 legal document templates, everything from NDAs to contractor agreements ready to customize, and a free legal consult if you're not sure what you actually need. And again, genuinely no pressure there. How to claim your free legal consult. Oops, sorry, go back. There is a link here somewhere. Yeah, Lawpath at Hyper. If you're here today through Hyper, and most of you are, I think, the link to claim your free 30-minute consult is at that link below. So just lawpath.com/hyper. Drop your business email in there, pick a time, and you'll be talking to one of our lawyers. The link will also be sent in like a follow-up email after our chat today. These are some of the lawyers. Great team up there. Again, we've all got different backgrounds. with different specialties. So again, we cover a really, really broad range of issues for our clients every day. That's wrapping up the end of today's chat. I think we'll jump into question time. Is that right, Sasha?
Yeah, exactly. So I'll probably just go top to bottom. But first of all, I just want to say thanks so much for presenting that. There's so many really good nuggets of information in there. Even from my own personal experience with Hyper, we've been in business for about 11 years now. We originally had 3 co-founders, and after the first 12 months went down to 2. And our company constitution, which really formed the early founder agreement, just made it such a seamless transition to redistributing equity and a few other different things. So yeah, getting it right from the start can save a lot of headaches later on.
Absolutely. Absolutely.
Nice. All right. So first question is going to be from Andrew. When is a good time to create an NDA for discussions with potential investors or users, or basically trying to make your idea public?
Yeah, look, I definitely, it's a good question. I think you're better off being safe than sorry, right? Like if you do have something that's got trade secrets in there that is really critical to your evaluating processes, and I guess anything that you can't hide, it really depends on your audience though too, right? And Sasha, you would see this with Hyper, like people want to look under the hood. And if your conversation is going to be, especially if it's in the software space or, it depends on the business, I guess though too. But if people really want to see where the value add is and it's not people orientated, I would definitely recommend getting one for sure. And the enforceability of those documents, if they're drafted well, they are effective. They are really good. I mean, again, enforceability of those documents does involve, cranky letters and, potential litigation, but it's a really, really good flag to, your audience that you're serious about what you're talking about and they can't be sharing certain things. So, I'd say sooner rather than later, but again, it does get sort of case specific. I hope that answers your question, Andrew.
Love it. And a second one from Andrew: is there a limit to how many investors you can have on a private cap table?
In a private cap table, I believe when it gets to 50, you become a public company. So, when you get to 50, I've seen there's other structures out there that sort of stop that from happening. But look, when you get to that level, of investors, it's a good problem to have, I'd say, rather than not. So.
Yeah, completely agree. You've got 50 people investing in you. You've probably got enough traction to make it worth it, right?
100%. I mean, look, and if you go public, you can have an unlisted public company, which is a lot of people don't realize that. But I'd say if you've got 50 investors, depending on the valuation of the company, then maybe you do go and list. Like that's a great position to be in. But you can absolutely have unlisted public companies, out there that, there's over 50 investors. There could be 60 or 70 different investors in those things. And a lot of the cost, that comes with that is, the yearly annual sort of administrative, tax, legal, all the reporting that goes along with it, some of the disclosures you need to make to your investors and stuff like that too. But yeah, I hope that answers that question.
Yeah, I completely agree. The one caveat there being equity crowdfunding. But a lot of people don't realize this, but equity crowdfunding is just like Birchal, for example, it's just one person that's on the cap table and they manage the distribution of shares or options on your behalf. So even if you go through equity crowdfunding, you're not going to hit that 50 cap super quickly if it's set up correctly.
Yeah, that's spot on. Yeah, the crowdsource funding model, there's actually they actually act as like a custodian or a trustee. It depends on their role, but they sit on that cap table as basically as a nominee or a custodian of the other interests there. So you're spot on there, Sasha.
Nice. This one's from Leah. What do founders often think they should prioritize legally, but in reality can wait?
I think, the one that I often see is like the really sort of complex shareholders agreement where it's all about management and control. And again, the first thing I ask clients who have investors is, will you have a passive investor here or will they be active? And what do you need from them? Like if you need something more from them than their money, then we need to get, you need to get something in place there and go through what I was talking about, through those vesting schedules and be really clear on that founders agreement. I often see founders go down the path of either shareholders agreements, founders agreements, which, complexity can give you flexibility in some instances, and I think founders want all the flexibility in the world. But I think when you really do sort of talk to them and go, well, look, what do you need to do in the next 12 months? And what do you need to do in the next 24 months? Like, if you don't need the flexibility, let's not get to the complexity of trying to address all that in these documents. So I would say it's in that founder agreement, but it's really just how it looks and what the necessities are. So I hope that answers your question, Leah.
Nice. This one's from Ursula. When should a founder pay for legal, and what's the first thing they're typically paying for?
When should a founder pay for legal, and what are they particularly paying for? I mean, I'd say the thing they're particularly it really depends on your understanding of the structure, right? Like, if you understand how a company works, if you've had a little bit of experience with, board meetings or, directors, resolutions, how corporate governance actually works, then I think a lot of those sort of really early sort of structuring conversations can wait, because you kind of have that understanding, you've worked in those environments. If you genuinely don't know what you're signing up to when you're operating a company, whether it's tax, what you're doing as a director, then I would say definitely spend half an hour. I mean, this is what we do here at Lawpath. I definitely think sitting down and understanding how that works is really, really important, especially the director's duties, because we'll often say, and I said it today, you get no personal liability when you set up the company. It segregates personal assets, but if you then go step in as a role as a director and then make creditor defeating, dispositions and trade whilst insolvent, and, don't understand what your reporting requirements are, then you're going to be personally liable for those faults anyway. So it's it's one of those things where it really depends on how much you know. If you do have that, knowledge, and you are confident with what it means to be a director and the like, I think the when do you speak to the lawyer is really when it really is a stakeholder assessment. I'd say, do I have investors? Do I have complex clients? Is my service delivery or offering getting more mature? Do I have money coming in the door now? I think it's a bit of a feeling. It's that uncertainty feeling that we sort of touched on. When you do have that uncertainty around, look, this feels a little bit bigger, it's starting to get, some growth here and starting to go beyond, my, what you can see and experience, I would jump and have a chat, see if anything needs reviewed. A half an hour with, a startup lawyer or something. I mean, it's not necessarily all Lawpath. There are lawyers out there that do this stuff. So half an hour goes a long way. And if you're really tricky, here's a hot tip: get on the phone to them for half an hour, ask them a whole lot of questions, and then you might not even have to sit down and consult. So, I hope that answers the question.
Definitely. And that's what's so good about the partnership that we've got here. So if you go to lawpath.com.au/hyper, you get that 30 minutes for free. And you can ask really as much as you possibly can in those 30 minutes. But they're an incredible business. So I'd definitely recommend taking them a bit further. Great. And then there's another question from Andrew. For solo founders, does the founder agreement still make sense? What legal documents would you have governing that if you're only a solo founder?
If you're a solo founder, you don't need any of that sort of that stuff just yet. I definitely think, depending on your business, I would definitely consolidate, like an asset register, your IP, do like an IP audit, make sure that nothing you're doing personally, because that's the other thing too, is like, if you are on your own, you kind of don't always have that sort of check and balance, that other party going, well, hang on, we might need to assign this, and you can often, just run with things, and there's no sort of other party sort of putting, any handbrakes on. I would definitely, if you're on your own, I would not worry about the founder agreements, shareholders agreements. It just won't matter just yet. But I would be really careful about maintaining that at those asset registers, basically making sure that the company is build those processes, build that documentation, that intellectual property base, depending on the business, making sure everything that is business orientated is going in there, because what you're doing is basically protecting someone looking at your business down the line. When you do have someone that wants to invest in, you might need to have a shareholders agreement or a term sheet starts floating around. That will show them that you're sophisticated in basically your business building, really, from a documentation perspective. So that's what I would recommend, Andrew.
Yeah, completely agree. I think at the end of the day, if you're looking to raise money, people need to know what they're investing into. And if you've tied an enormous amount of your work and your knowledge and your IP into your personal name, or you haven't built the processes that show people what they're actually buying, it can make it really hard to value a company, especially down the later stages. So yeah, I think it was a great question. We've got another question from Praney as well. I've read this a couple of times, but I'm pretty sure what he's asking is he's already built a company, but he wants to build a new product in a separate company so that he can bring on a co-founder for that separate company. So doesn't want to dilute the value of the original company that he has created in at the very start, but then wants to try and bring on a co-founder. So the idea of creating a separate company that owns the product and the IP, so that separate person could be most likely 50-50 with him.
Yeah, that's an interesting question. And obviously, again, this is probably one of those that gets a little bit more specific. But I just think if you're worried about, I mean, at face value, if you're worried about bringing on another co-founder into your existing company because there's basically the underlying ownership of the IP, like basically if there's evaluating process or product, the thing that's generating the dollar for your business, and you don't want to share some of that at this stage or dilute that, then absolutely set up a new company, keep it all separate. But again, if you just get it, I think there's a bit of an IP thing there. I'm going to guess, I'm not sure if you can say in the chat, but if it's an IP-based business, like if it's, if there's code, designs, websites, if it's some sort of product like that, then it's really an IP differentiation kind of question. Like, how do you protect your IP when you go off into this new venture? Because there's absolutely nothing wrong with going down that line and setting up a new company for a new product. Like that's all fine. But yeah, I'll just be really careful about what IP that new entity is going to be using or relying on in terms of your engagement. Because if you're not really clear about what you're stepping into, there could be an IP assignment nightmare down the line. But again, I take all of that with a grain of salt. That's definitely something worthwhile talking about. With it's a software platform. Yeah, so spot on then. Praney, yeah, it's definitely something you should talk about with one of us in the half-hour call. We'll talk about how you protect your current stuff and your current business when you step into that new one. But yeah, there's nothing wrong with setting up a new business with a new product and moving in. It's just making sure they're not going to leech on anything that you've done existing. So, again,
amazing. I think that's all the questions that we have in the chat at the moment. And we're basically out of time anyway. So thank you so much, Connor, for your time. Very much appreciated. If anyone wants to get that 30 minutes free, just go to lawpath.com.au/hyper. They will route you to someone like Connor just to talk about any sort of questions or issues or anything else that you have from there. And there's a few other things you get for free as well. But yeah, thank you so much for your time again, Connor. It was great to chat. And yeah, we'll connect after this.
Thanks, Sasha. Thank you, everyone, for coming along. It was great to connect with you. Thanks for listening to me. And yeah, hope to see you on some of those free calls soon.
Sounds good. All right. See you guys. Thank you.
Bye.